Anyway, so without further ado, maybe J Rapp, who is the third chief prosecutor of the Special Court for Sierra Leone, will tell us about his court and his achievements and the challenges that lie ahead for him.
Well, thank you very much, Leila. As she indicated, I'm the third prosecutor. David Crane, who you know so well, was the first, and Desmond Da Silva, now at night, knighted by Queen Elizabeth. Sir Desmond was the second prosecutor. I came to this post appointed by Secretary General Annan in the UN in December of 2006, after working almost 6 years at the Rwanda Tribunal, personally prosecuting the immediate trial that Massanjala mentioned in trial, and also working in other trials, appearing and cross-examining and examining witnesses and preparing other trials under the supervision of Prosecutor J Rapp. The Special Court for Sierra Leone is different, as Leila has highlighted. It has, first of all, a more limited mandate than the other courts. You've heard the others refer to prosecution of those responsible for genocide and other violations of international humanitarian law. Our mandate is to prosecute those bearing the greatest responsibility for violations of humanitarian law, but like the other courts, within a territory, in our case in Sierra Leone, and within a temporal period from basically November of 1996 until January of 2002. The court is a hybrid institution in the sense that a majority of the judges are appointed by the United Nations, a minority by the President of Sierra Leone. I'm appointed by the Secretary General. My deputy prosecutor is appointed by the President of the country. 60% of the people working in the court, employees, or as employees or as detailees, are Sierra Leone citizens. And I think it has made our institution much closer to the crime, much closer to the victim, and I think this has aided us in having an impact, albeit our mandate is of course a very limited one. And David Crane made the initial decision to indict 13 individuals, and that has been the full list of indictees of the court. There have been no guilty pleas, 3 big trials that have gone forth in Freetown, and now a trial of enormous international significance at the Hague. Let me just briefly mention the Taylor case, and I was interested in what Omar Ishmael said this morning. I so much agreed with him. He was talking about how there would come a day when witnesses would appear and testify against the President of Sudan and Omar al-Bashir in court. And I think many people in the world right now say, well, how could that ever happen? And that's a pipe dream. And I only have to take you back 5 years ago when David Crane initially, with a sealed indictment, but actually a public indictment, indicted Charles Taylor. He was president of Liberia, the same way that when Louise Arbour obtained the indictment against Slobodan Milosevic, he was president of then the Federal Republic of Yugoslavia. When the earlier indictment came down against Karadzic, he was president of the Bosnian Republic, essentially. Those individuals were never expected to be brought into custody, and they were. Particularly in Taylor's case, in August of 2003, in a classic negotiations of putting peace ahead of justice, or apparent peace ahead of justice, Taylor was allowed to go into a safe and comfortable exile in Nigeria. And at that point, I think no one thought that he would ever come to justice. But yet, in barely 2.5 years, and I was mystified that I wasn't there on that afternoon of March in 2006, when at 7 p.m. at night, as the sun was setting over the Atlantic, which the court is very near, and Freetown, one of those old Russian helicopters that we use in UN missions, came through the clouds, while thousands, indeed tens of thousands of Sierra Leoneans stood on the rooftops and watched Charles Taylor delivered to justice to the detention center of the Special Court for Sierra Leone, a reflection of an intense effort on the part of the court and of the international community, an amazing number of things that had to be done, that were done, that made possible that moment. And of course, for those of us who are prosecutors, that is very much only the beginning. And now continuing with that work with the trial of Charles Taylor in The Hague, trying hard to learn the lessons that have been learned by the tribunals over the course of the last 15 years. We know we don't have 4 years to try, and we know there's great criticism about these institutions taking too long and casting the evidence net too broadly. We're committed to basically putting all of the evidence in our case in about 18 months. We're well into it. We're now in the 6th month of the presentation of evidence. Today in The Hague, we've already had adjournment today. We have the 36th prosecution witness in the box testifying against Charles Taylor. We're hopeful to be able to complete the prosecution evidence. The judges recently are going to require us to call a few more witnesses on the crime base, but we're confident that in less than 6 months from now, we'll have concluded the prosecution evidence, and the defense has indicated they'll be presenting about 4 months of evidence. So by mid-2009, we'll have a finalization of the trial, and certainly by the end of 2009, a judgment on a case of immense complexity and importance. Everyone, of course, who followed the history of West Africa and read the news, knows about the alleged crimes of Charles Taylor. And of course, a lot of them involve crimes against his own people in Liberia. And we're not trying him for those crimes. We're trying him for what we believe he was responsible for next door. And showing the linkage between him, the responsibility, individual criminal responsibility for him, by him, for murder, for rape, for amputation, for acts that were really part of a campaign of terror against the civilian population, that included as well crimes of the recruitment and use and hostilities of children, enslavement of people for forced labor, for digging diamonds. Additionally, crimes such as pillage, and of course sexual crimes, an enormous part of the conflict, rape. Indeed, it's estimated that up to 1/3 of the women in the war zones, hundreds of thousands of women raped, tens of thousands of women turned into sexual slaves or bushwives, holding him responsible for those crimes when he never set foot in Sierra Leone is the immense challenge of the case. But our evidence is that indeed he was the person bearing the greatest responsibility for what those individuals were doing. And we'll talk later about the legal theories, about joint criminal enterprise, about accomplice liability, about the other ways in which superior responsibility, other ways in which individuals like Mr. Taylor could be held responsible. But each day we're presenting evidence which, as Mark said, is a matter of articulating that experience in the context of the law and the rules of procedure. And most of the evidence that we presented today has been that of insiders, people close to Taylor. In terms of the hierarchy, the closest person whose testimony I read in May was Taylor's own vice president for 3 years. Before that, as ambassador to Libya. Before that, as inspector general of this rebel movement. Before that, within the camps in Libya in 1989. But then finally his successor in August of 2003 in a move that shocked everyone in Liberia. He appeared as a witness against Charles Taylor and testified for 7 days in May of this year. But others have involved his key executioners, those who killed and sometimes cannibalized, people who he selected for killing, and people involved in the communication of orders, the delivery of diamonds, the delivery of material, the training, safe havens, and everything else. Obviously, a great many individuals who themselves have blood on their hands as one has to deal with those issues in any kind of prosecutions of organized criminal activity. You sometimes need the Johnny the Bull Bravano to bring down John Maddox. You have to define the persons inside the organization who may have very, very strange motivations, and their testimony may need to be intensely corroborated. But without that kind of testimony, you can't bring down the leader, particularly when that leader is the president next door and not someone bearing the direct command responsibility for forces in the theater of the war. That's the Taylor trial and legacy on Sierra Leone. I think we're well on the way to doing it. Thank you.
Thank you so much.